All right. Thank you, everyone, for being with us today. We have an ethics accredited CLE with Jaimee Reed, and Jaimee is the owner of Cairn's Insurance Services, Inc. She's an attorney, and she practiced in Arizona and Colorado. She focuses on malpractice insurance and specifically for small law firms. This is her 8th year in business, and she is one of our LawBank business vendors. It is completely illegal for her to offer us a discount, but she does offer all of you super great service when it comes to your malpractice coverage. And she has other colleagues, partner agents that work with her on workers' comp and health insurance. So I encourage all of you to reach out to Jaimee directly if you need a consultation on any of what I just described. So that being said, Jaimee, we're ready when you are.
Thank you so much. Yeah, thanks for having me. I appreciate you guys, and it's great to be here. And the first thing I'll tell you is if you're just here for CLE credits, I get it. I've been there. Turn off your camera and feel free to ignore me. If you hear snippets of something interesting and want to ignore the rest, feel free to call me or email me later if there's something you want to discuss. I will not be offended, I swear, especially it's the Monday after Thanksgiving. So do what you need to do. All right, so the first thing I'm going to point out is just basically the title of this, How to Stay in the Good Graces of Your Malpractice Carrier. The original title of this was That Lawyer Did What? Because there are some things, some examples I have that hopefully you are thinking, oh my gosh, I can't believe somebody did that. But they're real examples. Most of them are not. There's one example I'm going to give you from Colorado, but it's a family friend of ours, and I've told him that I'm going to use him as an example. Other than that, the other examples given are from outside of Colorado for obvious reasons. I don't want you to think, oh, I think I know who that is. You most likely do not, because it's not from here. Just a little side note. So I'm going to flip through. This is my first Zoom presentation, so sorry if it's a little fumbled, trying to figure out the screen share and all that. So bear with me on this. I'm flipping through. Hopefully you can see these slides. That's just my bio slide, which Miranda already told you about. So we'll just jump right into this. And if you want to answer questions, you can type them in the chat. That's probably easier. Or if you have questions to ask, you can do it there as well. So the first one we're going to talk about is cyber issues, and we'll have cyber issues kind of sprinkled throughout this presentation because we highly recommend cyber for all clients. A lot of people say, oh, I'm so small, I don't really have these kinds of issues. It doesn't really matter how small your business is, because it's not a matter of if you're going to get hit with this, it's when. So just something to kind of keep in the back of your mind. And I believe the ABA has also released a few things about ethical obligations for law firms and cyber policies. So we can discuss that another time as well. So the first example, everyone remembers the Nigerian prince email, I assume. It's still happening. Still, people still fall for this all the time. So I wanted to put that out there so you have that kind of in your head. But the first slide specifically pertains to a common way that hackers are able to trick lawyers into changing wire instructions. You know, it might seem like, how does that happen? It actually happens quite a bit. So the reason I mentioned the Nigerian prince is because that's something that a lot of us are like, oh, I recognize that, delete it. It's spam, right? Most people recognize it. However, when you get a change in a wire instruction from a client that says, hey, so-and-so, can you please send the settlement agreement to this account instead of this other one that we originally agreed on? Well, this is a big trick a lot of times. So what they'll do, what you need to do, the important takeaway from this is pick up the phone. Pick up the phone, call your client every single time. I don't care if you just talk to them on the phone and you get an email a second later, call to confirm this change, because hackers are studying languages, they're studying intonations, they're studying how people talk to each other in businesses, so they can mimic that. So they'll go in and study how your clients talk to you, and then they can mimic that to trick you. So the example that did happen in Colorado is one of my husband's friends. His name is Alan. Alan works for a guy who's just a jerk. He's an absolute jerk in every possible way a boss can be a jerk. He's rude, he's unprofessional. Not too long ago, it was about last year, I think. Alan got an email from his boss that said, hey, I need you to get me $500 worth of Target gift cards. We have to disseminate those to clients this afternoon. I need you to do this now. I don't have time for you to drive the cards over to me. Just get them, email me the numbers, and be done. The way the email was worded was exactly how his boss talks. Everything about it led Alan to believe this was legitimately from his boss. So he goes, he gets the gift cards, $500 worth. He gets back, he emails the numbers, everything, and goes on with his day. At the end of the day, he calls his boss and said, how did those go over? Were the clients happy with those? He said, what are you talking about? The gift cards, the $500 that you told me to get? He's like, I have no idea what you're talking about. What are you talking about? Proceeds to lambaste Alan for what he did. Well, it turns out that a hacker got in and studied how his boss talked and emailed him, and it looked like it came directly from him. So it is happening all the time, and just be aware of that. These particular cyber claims fall under what they call social engineering, cybercrime. There are different names for it depending on the cyber policy that you have, but it falls under this umbrella, if you will, of this social engineering cybercrime. To give you an example of how many claims carriers are seeing in this area is that excuse me, on a cyber quote, $1 million limits are pretty standard. They'll have sublimits on those main limits. Sublimits for things that fall into that social engineering, scam, phishing, cybercrime category. Those sublimits, if you have $100,000, that's on the low end, but $250,000 is a good sublimit, $250,000 to have for that. So that's something to keep in mind. If you have a cyber policy, double check that specific sublimit. So to give you an idea, the quotes for those policies generally come in around $1,200 for the year. So you have $1 million sublimit, and then you have a $250,000 cybercrime sublimit on there, about $1,200 for the year. To increase that sublimit just for cyber engineering, social engineering, not the full cyber limits, just the sublimit, to increase that from $250,000 to $500,000, you are looking at a premium increase from $1,200 for the year to about $8,500 for the year. So that should just give you an idea of the amount of claims falling under that category. Does anyone have any questions on that? Okay, I'm not seeing anything in the chat, so hopefully that means no. All right. Second slide. This slide has three, one's a word and the other two are phrases. I need you to look at those and rearrange the letters. These are reasons potentially for being non-renewed by your LPL carrier. So I'll give you a second to look at those, get your brain working on the Monday after Thanksgiving. Okay, and if anyone wants to type the answers, they can. So the first one is rogue attorney. The second one is lack of supervision. And the third one is 15. And we'll get to that in a second, what those mean. So the real life example that happened here with these is there was a law firm who had an extreme amount of turnover. They ended up getting non-renewed by their carrier because they had 15 claims in 1 year. 15 in 1 year. They couldn't defend themselves because this rogue attorney left, disappeared, and stole the files, every single file. So then when they were sued for malpractice, they had no idea. They couldn't offer any defense, they couldn't help, they couldn't do anything. So they were basically out of luck. The carrier said, absolutely not. We're not renewing you at all. This was not my client, so I don't know exactly where this one was placed. This was from one of my underwriters, this example specifically. So the takeaway from this is review the work of your associates, your independent contractors, of counsel, whatever it is. If it's not you, you need to review the work, unless someone is at your same level. It's a partner at your law firm. Obviously, they're responsible for reviewing their own, or they should be. But you want to make sure you're reviewing all of the associates' work and catching mistakes. Along with that, reviewing your associates' work is making sure you're hiring the right people. Because a lot of times people think, oh, well, I'll just hire someone. If it doesn't work out, you know, whatever, we'll just fire them, let them go. Well, besides the employment practices issues that come along with that, which I won't get into today, but besides that piece of it, if you are constantly hiring, firing, or having all this turnover, it's going to negatively affect your malpractice premium. And the reason for that is because it makes you look careless. You don't know what you're doing. You're hiring people to try to take up the slack and the lack of stuff that you know, and you're really not vetting these people. So it can look poorly on you. So I tell my clients, if you're thinking about hiring someone, call me first. We can talk about it. I can hash through different scenarios with you and potential pitfalls. So make sure you keep that in mind. And you should be able to call, if you're not my client, you should be able to call your agent and say, can you please help me through this? Can we talk about this? I don't know what to do in this situation. So just keep that in the back of your mind as far as, you know, when you're looking to hire someone, if you're not familiar with their work. A side note to that piece is, if this rogue attorney that stole all those files, if you or your firm has a cyber policy, it could potentially be covered under the cyber crime section. It's going to depend, those wordings vary quite a bit. It could potentially be covered, but that's going to depend on cyber policy endorsements, that sort of thing. Just something to keep in mind. All right. So the next few slides here are, it's called a situation poll is what I called it, because what we're going to do is think about things as you get more information on the situation in front of us. And I should back up for a second. Does anybody have any questions on the last one with the rogue attorney? Okay. All right, so this next one, let's go here. So this one's gonna relate to competence rule 1.1. So the first piece of information that you have here is you get a call. You have no experience with high dollar clients, but you get a call from a woman looking for help with a divorce. She has a terrible, convincing story, long sob story, divorcing the husband who now happens to live in Denver. So she calls you to help with this. Would you be comfortable, if you don't have experience with high dollar clients, would you be comfortable taking on this case just with what you know so far? Think about that. And then we'll add to it. So think about how your answer changes, if it does change, if the case is a divorce in Japan. Remember, you're located in Denver. And you're also not a divorce lawyer. Let's throw that in there. So think about that. How does that affect your decision? The more you go along, now you receive a document that's been translated from Japanese. She gives this to you. She says, okay, I need your help recovering this money. Here, I'll show you. Here are the divorce papers. Here's the translation. But there's no certification about the translations. There's not proper documentation, nothing. It's just supposedly a translation. So if you've been keeping track of these in your head, you know, think about whether this changes your answer. Next, you call the husband. He readily agrees. So those of you on here who are not my clients, I don't know how many of you practice family law. I did not when I was practicing, but I can still tell you that if the opposing party readily agrees to just writing that check for $250, no questions asked, probably a red flag there. I mean, I have a lot of friends who've gotten divorced, and I can tell you that none of their husbands readily agreed to give them anything, really, let alone just writing a check for $250. So that's something that should maybe strike you as odd too. But if you're used to dealing with high dollar clients, maybe not necessarily. So you're talking to him, he says, yeah, I have a few companies, they owe me money, it's not a big deal. I'm happy to get this check for you and have this be done. We're good to go. And make note that this conversation you have with him is on June 3rd. Shortly after that, a check arrives in the amount of $250. Think, okay, so he calls the bank. He did what he was supposed to do, or he thought he did. He called the bank, he verified that the check was legitimate. He made sure that there were enough funds in there to cover this, and it was fine. So he says, okay, so he immediately wired the money to the woman in Japan. You probably can figure out what's going to happen. So he did not notice, however, that the check was dated June 1st. He didn't talk to the husband until June 3rd. Then he gets a call a few days later, and the bank discovers, oops, check was either stolen or it had been washed. So now what happens? He's out of luck. But is he? Do you think that this situation would be covered under your LPL policy, which is your malpractice policy? Anyone want to answer? The answer is no. Your malpractice policy will not cover this. It is not an error, an omission. Yes, it was an error, but it was not in your professional services. So your malpractice policy is not going to cover this scenario. Now, again, with the cyber, it's possible the cyber policy would cover it. You'd have to see wording on cybercrime, et cetera, but it's possible that a cyber policy would, but your malpractice absolutely will not. So keep that in mind. So the takeaway, obviously, from this one, if you didn't get it, is don't take cases, one, outside of your area of expertise. So on those applications that you fill out every year at renewal, that has the AOP grid, this area of practice grid. So on that, you have to put what you did for the past year and your percentages and practice areas. If you start taking cases in areas in which you do not have experience, they're going to consider you to be dabbling. Dabbling in a practice area is, well, it's just not a good idea, period, for obvious reasons, but it's also not a good idea for your malpractice carrier because they do not want to see dabbling in areas. They want to make sure you have experience in it. And so I know you guys, part of the LawBank community, already know this, but that's one of the awesome things about LawBank is because you do have the ability to take cases maybe more outside your comfort zone than in a normal situation because you have the mentor situation set up with LawBank, which is so awesome. So this might not apply as much to LawBank members, but it's still something where if you just don't know anything about it, you need to be referring that out and not trying to learn something as you go. Okay. And, kind of like what your parents told you when you were little, if it seems too good to be true, probably is. I mean, having someone just walk in and give you this money, probably a little too good. Anybody have any questions on that or about taking things outside your practice area expertise? We are moving through this quickly. All right. Let's see. Okay. The next two slides, when I've taught this before, I'm still baffled that I have to even talk about something like this because I feel like I have a vivid memory of sitting as a 1L and having the professor say, don't have sex with your clients. Don't do it. Don't do it. And it seems like, okay, that should be pretty black and white. It's not. Apparently it's not. So try to keep that in mind. But let's talk about this example. So these slides are two truths and a lie, true or false, whatever you want to call it. So look through those. I'll give you a second to read them and let me know what you think. Okay. So the first one, it's permissible to start a relationship with a client you just met as long as you're doing so to protect him or her from an abusive relationship. Yeah, that's a lie. The relationship must begin prior to representation. Must. in the real life example I'm going to give you, this particular lawyer, ended up getting involved with the ex-fiance of a known mafia boss. So, side note, maybe I watched too much Sopranos, but I would stay away from that scenario as well. The second one, it's not permissible to advise a client to settle solely because one is on the verge of financial ruin, and settling the case is the only way you're going to recoup those losses and keep your firm in business. That's true. The wording is a little tricky in that one. So in the real life scenario, the lawyer recommended settling because going to trial is obviously going to cost a lot more money that he couldn't afford. He had so many debts to settle, and his justification was, well, she's still got tons of money. What's the big deal? Well, it's kind of a big deal. So try not to do that. The last one, is it okay for your father to pay for your insurance premium? Yes, it is. Yes, it is. Different rules apply than when you are representing someone who's paying their legal fees. But yes, the client did know in this scenario, but I'm not kidding when I said his dad called me and asked me to pay it. And no, the client was not a teenager. The client was in his 40s at the time. So this particular slide is, obviously dealing with some conflicts of interest and ethics involved in all of that. So your own interest cannot be permitted to have an adverse effect on your client. It doesn't matter if your client still ends up ahead of maybe where they even wouldn't be in trial. It doesn't matter. You can't take that into consideration when you're thinking of taking a client or even if it's a current client, representing them in a different matter. So in this particular case, the client hired the lawyer, and there was money involved. It was an engagement, and they had broke it up. She didn't want to return the engagement ring because it was about $500,000. So they were trying to figure out how to settle so she could keep this ring and move on with her life. There was a lot of domestic violence involved. I mean, shocking that a mafia boss would be charged with domestic violence. I know, it's very, very shocking. But there was domestic violence involved, and so this lawyer took on the role of rescuer as well. So there were all kinds of factors that played into it, but a big piece of it is because he had a sexual relationship with this woman. So needless to say, it spiraled out of control. Everything went wrong. They had a sexual relationship. Then she retaliated against him by filing bar complaints. And the biggest problem was that he caused her further injury. So by settling this, so he had a lot of bar complaints come out of this. It was a huge, huge mess. He was grieved a bunch of times. He ended up being sued by this woman, by former law partners. Basically, once this happened, everything spiraled out of control. He ended up having a lot of turnover in his firm. The firm name changed 3 times in the span of 4 years. And his premium, because of all of this, his malpractice premium went from $12,000 for the year to $100,000 for 1 year of coverage. And he was a solo. So we're not talking about, a 20 attorney firm here. We're talking about one firm, and his premium went up that much. His business is no longer in existence. Okay, the next slide, still along the same lines of sexual relationships with clients. So 3 more questions, 2 truths and a lie. I'll let you guys read through that one. Okay, so the first one, lawyers have received public censures after being caught in relationships with clients. This is true. That's true. It did happen. It happened. And this was actually one of my clients. He received a public censure because the client grieved him. In conjunction with the sexual relationship he started with the client, he had a lot of issues come out of this. So not only did he start a sexual relationship with a client after he was representing her, he then took her on as a confidant, if you will. and released all kinds of confidential information to his new girlfriend. He would send her settlement agreements to read and review and give, her feedback before he sent them to clients. Letters he had to send to opposing counsel, he'd send them to her and have her edit them. And remember, this all happened after she retained him. They started this relationship. So what do you think is the important thing to ask, or that even OARC should have asked about this particular woman in this scenario? The lawyer is man, the girlfriend obviously is a female. So what do you think should be a question asked about her specifically? Mitigating factors, basically. Well, was she an attorney? Did she work for him? Was in any capacity, was she employed by the firm? Was she a paralegal? Any of those questions maybe could have been some mitigating factors. The answer in this case specifically was no. So he didn't have those defenses, but had he not started this sexual relationship with her, none of this would have happened. So, and there were other mitigating circumstances in that I won't get into, but keep that in mind as well when you're, pillow talk should not involve discussion of settlement agreements. Number 2, lawyers are never disciplined for natural human behaviors like starting relationships with clients. Obviously, the answer to that. And lawyers are allowed to have romantic relationships with their clients. Yes, true, you are. The relationship must begin prior to representation. But seriously, people, there are millions of people out there. Find somebody else. It's not worth your career for that. So find someone else. Okay, any questions on that? If it's embarrassing, feel free to contact me later if you don't want to put some question in the chat to everyone. That's totally fine. Okay. And the next, let's move on to the next one. Okay. Slide number 10. Pick the options. There are 7 options on there. Pick which ones you think are most likely to earn you a call from OARC or, whatever your bar, if you're in a different state, whatever it's called, bar regulation. Look at those and let me know what you think about those. Check the ones most likely. Okay. So number 1 is the only one on there that's most likely not going to earn you a call. If you get a call for that, somebody must be over at OARC, must be super bored with nothing to do. They're not going to bother you about that if you just have the disgruntled clients. They do try to field a lot of stuff before they send out correspondence. So yeah, you're most likely not going to hear from them if number 1 is an issue. 2 through 7, you're going to hear about it. Now, number 3, you might be thinking, how is this relevant? Well, I'm going to tell you. So this particular example happened to one of my friends. So he took his wife, he owned a law firm in Phoenix, Arizona, and took his wife shopping at Scottsdale Fashion Square one day and went into the Louis Vuitton store, and she wanted a Louis Vuitton purse. And he said, money's tight right now. I'm like, no, I'm not getting this for you. She proceeded to throw a tantrum in the store, and they left. And he went home, didn't think anything of it. Well, she went into his law office when he was not there. An important side note to this, she's not an attorney. She did not work for his firm in any capacity. She has absolutely no legal training whatsoever. She went into his law office and started snooping around. So she got into the bank accounts and was somehow able to, we're not really sure how, but she was able to access the trust account in his office. Well, she doesn't understand. She's not a lawyer. She doesn't understand that the trust account is not the firm's money. So she sees this huge amount and proceeds to drain it. She takes all of the money out of the account. My friend did not have any idea this was happening. He was in court a lot and just wasn't paying attention to what was happening in his firm. right in front of his eyes. So she drained the account. She went and she got that Louis Vuitton purse, among many other expensive things, brought it home, threw stuff on the table. And he said, where did you get this stuff? And she said, oh, I saw how much money we have. And now it's my money too, because I'm your wife. And so here you go. Here's all the stuff I bought. So he proceeds to justifiably freak out because of what happened. She drained his account. She stole all of that money. Unfortunately, my friend passed away shortly after that. So none of us know what happened. His wife kind of disappeared, and we don't know what happened after this. However, again, your malpractice policy is not going to cover this. Someone stole all that money, but it is going to affect your malpractice premiums, because if you can't control your office and know what is going on at all times, it's your responsibility. You're responsible for keeping track of that money, making sure the trust account is not touched by someone who doesn't have authorization to touch it, and also keeping track of the money that's in there. And if your account, I don't know if you all know this, but if your account does tip below that and say a check bounces from the trust account, you're going to get a call, probably most likely immediately shortly thereafter, from ARC, and you're going to get a letter and they're going to investigate you, because they want to know what the heck is going on. Why are you so poorly mismanaging your firm that you don't even know that someone drained your trust account? So it's going to be reflected in your malpractice premiums, even though your LPL policy would not cover this example. So, and then you're going to have to fix it, and it's going to be a huge, giant mess, because again, it's your responsibility. Another real life example, this was not one of my clients, but another real life example is a law firm received a notice of a $70,000 transfer from their trust account. They had no idea that $70,000 was missing from this account. So obviously they received a huge hit at their malpractice renewal because of this. Now, that firm in particular did have a cyber policy in place, and as soon as they found out about it, they immediately deployed a breach response team from the cyber carrier, so they were fixing it. So in that case, it's more likely that they'll be able to recoup some of it, but obviously no guarantee. And you're not going to be able to recoup the money that you're going to have to pay in the increase in your premiums as well. So again, it's just not worth it to not know what's going on with your money and your client's money. Anyone have any questions on that? Okay. The next one we're going to go over is more about bar complaint. So this particular one specifically involves a conflicts issue. And obviously there are many things that could cause you to have a conflicts issue. This example just includes 3 that were highlighted in this particular one. And the reason I'm highlighting this one is because it actually got bumped up. So it wasn't just a bar complaint, but it actually turned into a complaint from attorney regulation against this firm. So it was escalated because of everything that happened in this. So the first 3 things in this main bar complaint are failure to explain vital information, failure to act diligently, and then concurrent client conflicts. So for me, when I was practicing, conflicts always just freaked me out. I just wanted nothing to do with it. And luckily I was at firms that ran it for me, so I didn't have to keep track of that personally. If you need tips on those, feel free to contact me, but conflicts are something that complaints are becoming more and more. And now during COVID, we're seeing so many more bar complaints and malpractice claims just in general. So this is something that, I think is fairly easy to control when you have a conflict situation and how to deal with that. I think it's easier to spot those than maybe other pitfalls that attorneys can come across during their practice. So in this particular example, a lawyer represented a business, and then she was representing the manager of the business in some personal matters, but then the manager had another business, another separate entity that she also wanted a lawyer to represent. So lawyer had discussions about conflicts between the two businesses, drafted the conflict waiver. It was very detailed. It listed everything. It was a great conflict waiver. Well, she sent the waiver to her client and said, you need to disseminate this to the other tenant. Well, what do you think happened? Tenant never received the waiver. Attorney only had an electronic copy of it, which also disappeared. There was nothing. She hired forensics to look for it. They couldn't find it. So no one really knows what happened to this. But the bottom line is she took the precautions and had people sign this waiver, but then it disappeared. So essentially, there was no waiver, and at least she couldn't prove it. So the tenants filed complaint, and there were issues with her coverage on this piece. So something to keep in mind as far as your malpractice coverage goes with your disciplinary complaints specifically, a lot of policies have specific amounts for disciplinary proceedings coverage. Some lump it into one thing that gives money to supplemental coverages. It depends on your policy wording, but something that caused an issue in this particular case was because the two complaints, there ended up being two bar complaints, they stemmed from the same issue. However, there were slight nuances in it, and there were slightly different complaints about this particular attorney. So the carrier tried to lump it under one, which significantly decreased her coverage because she had it split. So she had a $30,000 disciplinary proceedings and a $60,000 max. So they were trying to give her only 30 for this, or we were able to get them to bump it up to make it two separate. So she actually had more coverage for both. Because, and the importance there was because it escalated and then it turned into an actual complaint from OARC. So, and in that they alleged the three things I mentioned earlier. The failure to explain vital information because of the business structures and the potential risks involved in this one were so high. Failure to act diligently because she didn't follow up with the changes in corporate structures and she didn't follow up for the agreement, the waiver, and then the concurrent client conflicts because she wrapped both of them without the permission in writing, which apparently she got, but again, disappeared. So it might as well not have happened at all. So keep that in mind. And that kind of goes to what we talked about before as far as competence goes. If there's something that's really outside of your comfort zone, even if it's, shoot, do I have a conflict? I don't really know. Can I do this? You know, call somebody, call me if I'm your agent, call your agent if I'm not your agent. So talk to somebody about this if you're really confused. It's better to call someone and figure that out instead of suffering through that increase in insurance premium, because a similar thing happened to this client. Her insurance premium doubled. And I don't mean like $2 grand to $4 grand. It was significant. It ended up being in about 25,000-ish when all was said and done. So, and again, that was for a solo. So kind of a big deal. So in my opinion, you know, I would say just conflicts in general just aren't worth it. You know, sometimes there are exceptions and you can get around those, but make sure you're documenting the heck out of everything. The other example in conflicts that has come up is failure to advise about life insurance proceeds. So in the particular real life example here, the lawyer was representing the mother, the son, and the daughter in the estate of the deceased father. Well, it turns out that mother was accused and later convicted of killing the father. No conflict waivers were obtained in this at all. So after the mother's conviction, the adult children alleged that they were not properly advised in the repudiation of their rights in the life insurance proceeds. So again, if something's outside of your comfort zone, get help with it if you're not sure. And if there's a conflict, my advice is get rid of it. And if you can't get rid of it, then document it. Any questions on conflicts? Okay, and I got a question here from Jay that says, asked me to speak of increase in claims due to COVID. So increase in claims apparently all across the board, even in types of insurance I don't place. They've been increasing, and the market for lawyers specifically has been extremely volatile, especially in Colorado. Carriers are telling me they're seeing tons of claims in Colorado, and basically it's, people are litigious by nature, and now that's exacerbated. So with COVID issues and people losing their jobs, people are trying to figure out essentially any way they can get some money, and that's causing issues with lawyers. The other thing that's happening is that people aren't paying their legal fees, which is a big problem across the board. I'm sure some of you have experience with this, and actually we're going to touch on that in a minute. But when they're not paying their lawyers' fees, so then lawyers are sending them to collections or trying to sue for fees, and then they're pulling malpractice claims. So the increase is kind of across the board and for various reasons, but that's what I'm being told by my underwriters. Now, for my clients specifically, I have seen some upticks in bar complaints and some claims, but fortunately, I have awesome clients, and they, it just doesn't happen a ton with my clients, but in general, it's on the uptick. So keep an eye out for that. And we can talk about the fee. We'll talk about the fee stuff in a second, but just so I don't forget, one of the ways to get around that, if your practice area allows for it, is collecting higher retainers initially and making sure people replenish those before they're depleted. But again, we can talk about that later, but that's just something to keep in mind. But people are definitely looking for ways to get money these days. So looking for any possible avenue. Okay, let's see. Okay, so the next two slides there are 8 questions total. So read through those and then let me know what you think as far as true or false for each one. And I'll flip to the second slide in a minute so you can see those next 4 questions. And I'll go over these 2. Okay, so anybody want to venture a guess to the answers? No one knows. Okay, they're all false. All of them are false. So you should see the theme after these 2. False. One should always sue for fees, especially if the possibility is explicitly explained in the engagement letter. I don't care if you say it 50 times in bolded 14-point font in your engagement letter. Don't sue for fees. If I'm your agent, call me so we can talk about other avenues to get around suing to fees. And collections, sending to collections or sending to a collections attorney is the same thing in the eyes of an underwriter. It's the same as suing for fees. As soon as a client even mentions the possibility of suing you, you should contact your malpractice carrier. False. A lot of people think that's true. False. The reason for that is because you might be jumping the gun. So a lot of people think, oh, if I report everything potential, that looks good. That makes me look cautious, like I'm aware of what's going on. Not always the case. Some underwriters might look at it that way. Most of them don't. Most of them are thinking, what the heck are you doing that you have so many potential claims out there? Why are you reporting all of this stuff? So, it can get tricky because you think you're doing the right thing. Oh, I'm supposed to disclose this, but it could bite you in the butt when premium time comes around. It's generally a good idea to send a letter to the client or defense counsel responding to that demands letter. And you should do this before you contact the carrier because there's a good chance of settling it quickly. Again, false. Most policies have wording that you're not really permitted to do that, for one. For 2, no, don't respond because you might accidentally admit something. Even though we're all attorneys and, we like to think we don't make mistakes and we're all so smart. I mean, I know you all are so smart, but, we all make mistakes, and you need to make sure that you don't overstep and that you don't violate the contract, because remember, your insurance policy is a contract. So keep that in mind on that specific piece of language. What's also important is to understand the definition of potential claim. in your policy. So make sure you know that as well. Again, that's something your agent can talk to you about. I have clients call me all the time for something. Jaimee, can we go over this? Oh no, I have this issue. Do I need to report this? And we hash it out. And sometimes, yes, we do need to report it. And other times we can kind of wait and see what happens. So it's obviously case specific in that instance, but just keep that in mind. Number 4, it's okay to take those iffy clients, you know, the ones that you're like, I just have something is off, I can't pinpoint it. Listen to your gut on those. Iffy clients, oh, man, I hear it all the time. Clients calling me, if this person won't pay me, I just had a bad feeling, but I felt bad for this person. You need to trust your gut on those. And I think that comes with age and experience. And the more you're around people, the more you can vet people in your own firm, the more likely you're going to be able to pick those iffy ones out. You know, the ones that make excuses, or the ones that have had 50 attorneys already. You know, look for those red flags, because anything you can do to protect yourself is also going to keep your premium down. Next slide. Okay, customary to wait to respond after you attempt to settle it. Again, don't do this. And it might, you know, I feel like I'm kind of talking to kids sometimes when I say this, and you probably feel like I'm your mom preaching at you, but it's one of those things where these examples are here because they're still happening and people are still making these same mistakes. So keep that in mind. Like, you don't, I know we have this inclination of like, oh, I can take care of this, I can handle this. Well, that might be true, but you need to make sure you go through your carrier first. And along those lines, number 6, your firm is a named insured, so you get to decide what you're going to disclose. It doesn't work that way either. You need to follow what the claims handler tells you and listen to defense counsel. Number 7, a viable defense to disseminating confidential information is that the sender was inebriated. No, that is not a defense, and you're going to have some issues with your premium. You're going to have some issues with OARC, and potentially even steeper issues than that if you are trying to use that as a defense. And that was a real life example. If someone did that, sent out a bunch of confidential information to judges, other attorneys. That was kind of a mess. Thankfully, that was not my client either. And let's see, number 8. We already touched on this, but it's okay to send to collections for not paying for fees after one documented warning. Again, call me first or call your agent, because this is something where it can be often case dependent, where there are some times where suing for fees or sending to collections, you know, could be, I don't want to say fine, but potentially okay or permissible. And it's going to be scenario specific on that. So you want to talk about why this is happening, and I can help you through ways to make sure that you get those fees. And we have other alternatives besides sending to collections or suing for fees. And that about wraps it up. Anybody have any other questions? You guys I can send you the written materials that I have too. I think it's on my screen share on the side, just in case you need rule references on that, as far as which ethics rules are going to pertain to those examples. You know, if you want to read those, if you're having trouble sleeping at night, you have some insomnia, you want to cure, you can take a look at those. And in those written materials, I'll have just some helpful tips as well on those. And again, if you have any questions or want some more information on something, feel free to reach out to me. Oh, sorry, I think I just heard that. Sorry about that. My cell phone is listed on there, and most of my clients have my personal cell, so feel free to use that. And my email address is obviously on there as well. And Miranda and Jay have my contact information too. So I guess that's it, if no one has any other questions. Jay,
I think this was really great. This was really super helpful. Jaimee, I think what was super interesting to me was the don't pursue the when clients owe lawyers money. I've seen, you know, in 22 years of working with law, so many lawyers ripped off because
Yep.
most clients kind of know that they won't pursue them. Do you have anything, I've worked with collection agencies and stuff like that work with lawyers in particular, and they do try and keep it outside of litigation, but is there anything aside from taking larger retainers that you can help the solo and small firm community out with when it comes to kind of collection issues? It's a big deal for them.
It is. And this is one of the things about this industry, honestly, that infuriates me, because it's just, just for lack of a better phrase, it's just unfair, because you do all of this work and then the client says, nah, I don't know, I don't feel like paying you. And yeah, it happens all the time. And it's not just, from what I've seen from my clients, it's not just kind of $1,000, here and there. Like, it ends up being big chunks of big chunks of money. And I think one of my clients was owed 40 grand. That's a lot of money. And it's like, if you can't, how do you recoup this? So and actually, let me mention, just in case people don't know, that it's 25% is your chance of pulling a malpractice claim if you sue someone for fees, which is why it reflects negatively in your premium, or it can. Now, besides getting larger retainers, again, it's practice dependent, so it can be tough depending on your practice area. But besides the larger retainers, you can also do things like flat fee arrangements have been pretty successful for clients. Setting up payment plans can be helpful. A lot of times my clients have found that their clients are more amenable if they can put them on some sort of payment plan. Not everyone wants to accept credit cards, but I think it's easier now. There are so many programs that small businesses can set up to where they don't have to be gouged for accepting credit card payments. So that's another option. Those are the main ones. But I do say, like I said before, if you're my client, please call me, because we can go over like everything you've done. And if we basically, for other clients that have had this issue, we make a file. Essentially, like, I have notes and I have a big file that documents everything they did. The statute of limitations for malpractice in Colorado is 2 years. So most people, if they're waiting until that 2 years is up to try to collect those fees, most of the time you should be okay. That's not saying the SOL can't be reopened, because it has happened, not to any of my clients, but from what underwriters tell me, it has happened. So that is an issue. But if you think about taking all of those precautions, like, we can usually explain it away. If there's some big client that owes you 50 grand, we'll figure it out, how to help you navigate that to get them, and to not have it have a negative impact on your insurance premium. And that's the big key, is to make sure you're protecting yourself, so that we can explain to the carrier at renewal, okay, she did this. This is why she did this. Let me explain this to you. And then we map it out. And though in times like that, that can help assuage an underwriter's fears as well.
Jaimee?
Yeah.
Jaimee, this is Mark Solomon, and I actually do a lot of legal malpractice work.
Oh.
So I want to just, your answer, or what you were saying just there, I just want to sort of highlight a few things.
Sure.
You're correct that the statute of limitations on a malpractice claim is 2 years from the day the client knows or should know that the lawyer made an error. But a malpractice claim is a compulsory counterclaim to a fee claim, and vice versa. A fee claim is a compulsory counterclaim to a malpractice claim. And if you bring a fee claim against a client 3 years after the representation ends, then you probably will get sued. And it's not that it could happen or there's some trick. It's that because it's a compulsory counterclaim, the filing of the fee claim opens up a statute. And there's in the statute of limitations sections, there's a revival section. I think I'm not looking at it, I think it's 138109 is the revival statute. So that revives a dead claim. And so, I bring those claims all the time outside of a 2-year statute of limitation, when somebody sues my client for you know, $6,000 left on a balance on a divorce case. And I'm like, you know, you might want to drop this thing because there's a $200,000 malpractice case that they were willing to let bygones be bygones because they wanted to get out of this problem in their life.
Right.
But if you want to come after them for $6,000, please go ahead and call your carrier.
Yeah, exactly.
So I've done that a lot. So I just want you to understand, it's not that it like that there's some weird exception. It's actually the revival statute. So it's specifically provided in the statute of limitations that renews the claim.
Right. Yes. Yes. No, you're correct. I didn't phrase that the right way.
Good.
Before. Yes. Thank you for reiterating that. Anyone else?
I think this was super helpful. Thank you so much, Jaimee.
You're welcome. You're welcome. No problem at all. Happy to be here. Happy to help. And happy to field any other questions via email, phone, whatever.
I attached the accreditation to the chat, but if anyone has a difficult time opening it, let me know and I'm happy to send it to them.
Awesome. Well, thank you so much, everybody, for joining us. And thanks again, Jaimee.
Thank you, guys. Have a great day and happy holidays, everyone.
You too. Bye-bye.
Bye.